estate planning. Kim is a former president of the BDSRA board and was the president when I came to my very first Batten's meeting. And I was so impressed by her and her leadership that I said to myself, you got to get involved with this community. So here I am 12 years later. Kim is an estate planning lawyer based in Kansas City. She got her law degree from the University of Missouri and has been practicing estate law now for a number of years. I think that estate planning is not a subject we all want to think about because it implies our own mortality, but I think it's a very important thing for our families to do. It's a wonderful gift to give them to not have to figure out what to do with all of our assets and to make need long-term care. So without further ado, here's Kim.
Okay, thanks for the introduction, and I do agree. I think estate planning is a topic that most people don't want to think about, but it is important. And I have a lot of clients who come in and they don't even know where to start. And so my goal today is to kind of give you just some basic things to think about with estate planning. And I've kind of have some written materials that I will give you at the end if you want that kind of summarizes what we're talking about today. But I mean, estate planning, it is kind of what you think about. It's making sure that your assets go to the people you want in the most efficient manner with the least taxes and expenses, which generally involves, avoiding probate. And if you have businesses, making sure that your business is transferred to successor owners in the event of your death. And so I'm going to kind of go over, what is probate, whether you should use a will or a trust. I get that a lot. Incapacity planning. We'll talk a little bit about taxes and a little bit about charitable planning at the end. So, and then if there are questions, we can go over any questions when I'm done. But I'm going to start out with talking just a little bit about probate. And I guess before I start, I would just say, I'm licensed in Missouri and in Kansas. So obviously I can give you specific information on those state laws. Anything else, I'm going to try to be pretty broad. Most states, just so you know though, especially with respect to probate, trusts, things like that, many states have adopted the same uniform probate code, uniform trust code, some variation of that. And so a lot of the state laws are pretty similar. The only exception I would say is Louisiana, which is based on French law, where everybody else is based on English law. But most states, their laws are going to be very similar. They might have small differences, but generally the things that I'm going to talk about are going to apply to most states. Some states, the probate proceedings are a little bit simpler, but most states you're going to want to avoid probate. And if you've never experienced probate, the primary problems are that it delays the distribution of assets that go through probate. I would say generally probate lasts about a year. Even if it's a pretty simple probate, it can last much longer than that if there are, a lot of issues. The primary thing is, you file a will to open the probate if you have a will, or someone petitions to open the probate estate, and then in the event there's not a will, then the probate assets pass in accordance with state law. Every state has laws that say if you don't have estate planning documents in place, then these are going to be, these are your beneficiaries, and it would generally be your spouse and your children and your siblings and kind of on down the line. And so once you file the will, there's always going to be a period of time that the creditors can file claims. In Missouri, Kansas, it's 4 months and 6 months. So, if you have to wait 6 months where you're just sitting there waiting to see if creditors file claims, it's always going to be a pretty lengthy process to get through probate. The The other thing is, the probate process is expensive. You have to hire an attorney to handle probate estates. So you're going to be looking at attorney's fees. It's a public process. Everything's filed with the probate court. So, like, you file an inventory of assets. They're going to, anyone could go to the court and get a copy of your will. They could get a copy of your probate inventory to see what your assets are. I kind of tell people you can tell, like, celebrities who've done their estate planning and who did not, because if anything is published, then you can pretty much assure that they've got a will as the main document in your estate plan, or they didn't do any estate planning, and so now things are going to having to go through probate, because it is a public process. So most states you're going to want to avoid probate, and so the first question, I guess, is how do you avoid probate? And one of the most important things I would say to remember is that assets pass at the time of your death in accordance with the way they're titled or beneficiary designations. And whatever estate plan you have in place, the asset titling and beneficiary designations are so essential to make sure that they're consistent with whatever plan you have. Clients will come to me after someone has passed away, and I think they're kind of surprised because usually one of my first questions is, do you know what their assets are? Do you know how they're titled? And do you know what whether there were designated beneficiaries? Before I even know, is there a will? Is there a trust? Because if the titles aren't consistent, it's possible you've created a will or created a trust, and no assets may pass under those documents. And what I mean by that is, so if you have assets that are titled jointly, most joint ownership is with right of survivorship, which just means if I own an asset jointly with my spouse, at my death, the asset's going to automatically pass to my spouse at my death. If I have an asset that has a designated beneficiary, that asset is going to pass to that designated beneficiary. If I have an asset that's titled in the name of a trust, that asset's going to pass in accordance with the terms of the written trust agreement. If I have an asset that is in my sole name and it doesn't have a beneficiary designation, those are the assets that have to go through probate, and that's what you want to avoid. And if you think about it, if you've got a bank account and it's titled Kim Zellmer and I die and there's no designated beneficiary, the bank doesn't know where that asset is supposed to go. And so the probate process is to make sure that at the end of the process, the court issues an order of distribution that lists that asset and said, here's who the beneficiary should be. So probate is a way to clear title to assets that you hold at the time of your death that don't have any beneficiary designation, so they don't really know where they're supposed to go. The other thing to remember is wills only govern where probate assets go. So a will is what tells the probate court where those assets that are in your sole name are supposed to go at your death. And so I also have clients who come in many times and they say, I need to have a will because I want to avoid probate. And I tell them, if you have a will is only going to be effective to pass assets if they go through probate. And so I also think that's something important to remember. And so then the next question becomes, well, do I use a will? Do I use a trust? What asset, what is the best plan for disposing of my assets? And really, I think if you're trying to choose between a will or a trust, in most states, I think what you're really choosing between is, am I going to use a trust or am I going to use what I call our non-probate transfers, which is joint ownership, beneficiary designations. Because I think those are probably going to be the two choices that are going to be the most efficient way to dispose of assets at your death. Most people are not going to want to use a will as the main document in their estate plan, because using a will mean that those assets have to go through probate to pass under the terms of the will. Okay? And so when you're trying to decide, should I use a trust or should I use a will, I think it depends on the types of assets that you have and how you want them to pass, and how complex your estate is. Revocable trust, if you haven't had to deal with it, I think sounds very complicated, and most people will say, I don't need a trust. I mean, that's for the wealthiest of the wealthy, and I think that that can be true in one sense, in that certainly people who have more complex estates, bigger estates, I think are going to want to use trusts. But I also think that regardless of the size of your estate, you just have to look at how you want it to pass and whether or not you can do that effectively using beneficiary designations primarily. And if you can use beneficiary designations to pass your estate, then that might be a good enough plan for you. If you've got a smaller number of assets, if you want it to go pretty straightforward outright to adult beneficiaries, that might be an option that you want to look at. If you have more complex estate, or if you want to have assets continued in trust for your beneficiaries, for example, then a lot of times a trust is going to be a more efficient way to dispose of the assets at your death. With a revocable trust, just to kind of back up a little bit, because I think, again, a lot of people don't really know what a trust is and how a trust works. But you're going to have a written trust document. In the trust agreement, a trust for estate planning purposes, generally the basic estate planning trust is a revocable trust, meaning it can be revoked, it can be amended. In the trust agreement, it's generally going to say, there are three basic parties to a trust agreement. There's the grantor. It's called a grantor, settlor, trustor. Different attorneys use different language or different states. I'm going to call it the grantor. But the grantor of the trust is the person who creates the trust and puts the assets into the trust. And then you've got, obviously, a trust beneficiary, and that's who the assets are held for, who's getting the benefit of the assets. And you have a trustee. And the trustee is responsible for managing the trust assets, investing them, filing the tax returns if they need to have tax returns filed, and then distributing the assets to beneficiaries in accordance with the terms of the trust agreement. When you set up a trust for estate planning, generally you're going to be all three of those parties. So while you're living, the trust agreement's generally going to say the trust assets can be used for my benefit. If I become incapacitated, a successor trustee will step in and will use the funds for my benefit. And at my death, here's how I want the trust assets to pass. And so the trust agreement is very flexible, and it can set forth, how you want everything to go in the event of your death. Let's see. So when you're kind of thinking about, do I use a will or do I use a trust, I think the trust agreement, a few of the benefits are it can provide for multiple backup beneficiaries. If you use beneficiary designations, for example, you're only going to be able to list a primary beneficiary, a contingent beneficiary. With a trust, you can put in there, I want it to go to my child if they're living. If they're not, it goes to, their siblings if they're living. If not, it goes to my grandkids. It goes to charity. And so you can put many backup beneficiaries in a trust agreement. With a beneficiary designation, you're going to be more limited in what you can do. The other thing I think with beneficiary designations you have to be a little bit aware of is if you use beneficiary designations to pass all of your assets after your death, then there's never going to be an executor or a trustee or anyone officially appointed to handle the administration of your estate. If you think about it, if you've got bank accounts, you've got your Schwab account, you've got your IRA account, everything's paid directly to the beneficiaries. So if you've got multiple beneficiaries, they're going to have to work together after your death to make sure that your final bills are paid, your final tax returns filed. And so that's something else to consider, whether or not your beneficiaries will be able to do that. The other thing, I guess, that I would also warn people about is putting assets in joint names with their children. I think that's sort of a lot of clients come in and they say, well, I've just got my children on all of my assets. I've just put my kids' names on that. And the problem with that is there are several issues that you really need to think about. One is that whatever problems your child might have, you might have inherit some of those problems. If they've got creditor problems, all of a sudden you might have your assets exposed to their creditors. If they're getting divorced, their spouse might try to make claims against your assets. If you've got assets that appreciate in value a lot, it can also cause a loss of what's called a step-up in basis at death, and I'll talk a little bit more about that when we talk about taxes. Oh my gosh, sorry. But it can cause more income taxes for them after your death if their name is on the title before your death. If you own real estate and you've put your child's name on the real estate and you decide you want to sell it, not only does your child have to agree, but in most states, their spouse will also have to sign the deed to transfer the real estate. So joint ownership with kids, I think you have to be pretty careful. The other thing is, a lot of times parents will say, I put my one child who is going to handle everything, and then they'll just make sure it gets all distributed out to my other kids. And I think, I think that they don't understand that there's a lot of issues that arise with that. First of all, there is no legal obligation on the child who receives the account to distribute it to the other siblings. And sometimes after someone passes away, the parent passes away, maybe the child gets a little irritated with their siblings and they decide, I'm just going to keep it. Or maybe their spouse gets involved and says, well, you don't owe them anything, you should just keep it. Or they find out that they have to pay gift taxes or file a gift tax return if the value of the assets are more than their annual gift exclusion. So having assets titled jointly with kids, I think generally is not the best estate plan. I think beneficiary designations are fine, and I think joint ownership between spouses is fine, but you should be careful about putting your kids on your assets with joint ownership. So let's see. We've talked a little bit about avoiding probate by making sure that you've got assets that have beneficiary designations. If you have a trust in place, the way that you avoid probate with a trust is you've got to have assets that are titled in the name of the trust, or you've got to name the trust as beneficiary. And if you don't do that, then assets aren't going to pass in accordance with the terms of the trust agreement. So what happens is, if I've got that bank account that was titled Kim Zellmer, and at my death, and there's no beneficiary designation, then that has to go through probate. If I had gone to my bank and said, I have this trust agreement in place, and I want to title it now in the Kim Zellmer Trust, that account is titled in the Kim Zellmer Trust, and in the trust agreement it says, in the event of Kim's death, she's got a successor trustee. She's named Barb as the backup. So then Barb, at my death, Barb just goes down to the bank. She says, here's the trust, here's the death certificate, I'm the successor trustee, and she has access to that account. And so, because the trust continues even after the death of the grantor, the creator of the trust. But you have to remember to title assets in the name of the trust if you have a trust agreement. And that's also something that I find a lot of times people will spend a lot of money to have estate plans prepared, and then they don't take the next step, which is to make sure their asset titles and beneficiary designations are consistent with that plan. So when you're trying to choose what type of plan is best, if you choose a will, then I think, again, you need to make sure that you've got beneficiary designations on all of your assets. And you have to make sure that that's the best plan. I think if you have assets that are going to be transferred to adults, I think that beneficiary designations can work fine, especially if you don't have a lot of assets. But if you want assets to continue in trust for a minor beneficiary, for a child, that's going to be incapacitated, I think trusts work much better. I think if you've got real estate in multiple states, again, that might be a reason that you'd rather use a trust. If you have your own business or more complex assets, I think that would favor using a trust. And I think finally, I think a trust is better if you want to do if you're worried about your incapacity. If it's for, if I have an older couple who comes in and we may have concerns that maybe one of them may become incapacitated, a trust is a much easier way to have a successor trustee step in and handle the trust assets if the creator of the trust becomes incapacitated. So I think I've kind of covered. Are there any questions about using wills versus trusts?
I do have a question.
Uh-huh.
Last night we were visiting, and Kate was telling us that Kate Howard.
Oh, okay. Uh-huh.
But anyway, we were discussing about the trust and everything, and she said that she recommended even like some banks will be your trust person.
Right.
That will be in charge of your trust.
Right.
If you fill it out, so that they will then take care of it. If anything happened to you, they would be
Right.
making sure that it was everything that you wanted done was honored,
Right.
instead of like not knowing who was going to take care of everything when you die.
Right. I think that that is a good point. I think one of the important things if you use a trust agreement is who is going to be the successor trustee if you become incapacitated or at your death. And I think that typically it's going to be an individual. Sometimes it's family members, sometimes it's bank or trust companies, and I think the choice between the two, I think it does depend on kind of how complicated your estate is, whether it's going to continue in trust. I think that, and also whether you have good choices. Sometimes, family members, they're just not really great choices of family members that you don't really want handling all of your assets.
Or your children.
Yeah, or,
not
yeah,
like,
right, right. And so I do think it depends, but I think certainly banks or trust companies are a great option, especially if you don't have someone who you feel like would be capable. And in particular, if it's going to be a more complicated trust, I think that's a good idea. I think sometimes your siblings, your children, but I think having a sibling as a trustee over a trust for another sibling, I think you have to really give that a lot of thought, because sometimes that's not the best plan either, because you have a sibling who's having to go to their, a child having to go to their brother and ask him for money whenever they need money, and that can cause conflicts that you don't necessarily want. Another thing to think about is if you name a corporate trustee, a bank or a trust company, I always kind of like to name maybe a family member as a co-trustee, because the bank or the trust company, if you've set up a trust you want to set up a trust for your child, you want somebody who is going to know your child and know you and kind of know what you would want, I think, to be involved in decisions about how those funds are going to be used for your child. And I think sometimes you don't have great choices, or maybe you just don't want to burden someone with the responsibility of having to serve as trustee and file tax returns. And especially if it's a trust for a special needs child, maybe you don't want them to have to worry about all of the Medicaid laws or things like that, what's appropriate to make distributions. And I certainly think in those cases, if you've got a corporate trustee, they can handle kind of the heavy lifting on filing tax returns and doing those kind of things. But having a family member or a friend or someone be a co-trustee with the corporate trustee, I think I'm a fan of that, of doing that, because then you've got someone who can have personal knowledge and say, I think this is a great thing. This is exactly what Darlene would want, done. This is how the funds should be spent. Or maybe it's a kid that you're just, they could say, this kid's not making great choices and we shouldn't be giving him much money, So I think there's a variety of options with trustees, and I think it's just something you have to sit down and just kind of have a heartfelt thought on, is this person going to, be the best? If it's just an outright distribution of assets after your death, if it's just, at my death, we're going to distribute it out to, these two kids or these charities or whatever, I think, an individual can probably handle that. A lot of times kind of the kind of horrible stuff that you have to do, if you have to sell things, personal items, and clean out a house and things like that, a lot of times it's the individuals that are doing that anyway. So I think you just have to think about what the circumstances are, but I think you could definitely choose, individuals or a bank, or you can have co-trustees, two individuals, a bank and an individual, and you just kind of have to think about what's best given your circumstances. And I think with a trust, if you're going with a trust or a will, I think you have to think about, what's going to happen, not only who do I want, but what happens if that person doesn't survive. You kind of have to make sure you have contingency planning. If you name a trustee, a successor trustee, try to name at least one, one successor. I mean, more if you have more, but make sure that you've got contingency planning in your document, because two, we don't know if we don't know we don't know what's going to happen, and so it's good to have backups. So I think that's.
What age should you think about setting up a trust? I mean, like if you're in your 20s, is a will sufficient?
I think it depends.
You have a lot of money.
That's what I was going to say. I think my experience is people in their 20s don't really have a lot. I have a child that's 25, and she doesn't have a trust. And it's a pretty simple estate plan. She doesn't have a lot of assets, but I think if you've got bank accounts, even if you own a house, many states have where you can do beneficiary deeds or transfer on death deeds, so you can actually designate beneficiaries on real estate. So a lot of people, if they have pretty straightforward, this is how I want my assets distributed at death, then I think they can use, like I said, beneficiary designations, beneficiary deeds on real estate. Now, some states don't have transfer on death deeds or beneficiary deeds, and so if they don't, you won't have that option. And certainly, if that's the case, if you own real estate, in particular, if you own real estate in multiple states, that's going to kind of lean towards favoring a trust, because if you have real estate and it's just in your name and you own it in different states, then not only do you have a probate estate, you have a primary probate. Your main probate is always going to be in the county where you reside. But if you own real estate, you have to have an ancillary probate in the counties where the real estate are located. So it can be really expensive if you have that. And another thing I think is, for married couples, a lot of times, they have everything titled jointly, so they say, oh, I'm covered because I've got everything joint with my spouse. But what happens if something happens to both of you, or close in time to both of you? And so when clients come in and they say, well, do I use a will? Do I use a trust? And we kind of go through, what I've talked about is trying to look at what their assets are. Does it make sense that they can distribute them by beneficiary designation, or do they need a trust? I think, if you choose to use beneficiary designations, you got to have beneficiary designations on everything. Joint accounts, you still should have a payable on death, a transfer on death, a beneficiary deed. And if you use a trust, you've got to make sure that you go through and all of the assets are titled in the trust, or they name the trust as a beneficiary. That's really the key. And that's why when I first started, I said, one of the first questions I ask is, what assets do they have and how are they titled? If somebody passes away, rather than what are their documents in place. Because if they've got all of their accounts, if Barb has a trust that she went to an attorney and she paid, a couple $1,000s to get this thing set up, and she has everything joint with me at her death, then nothing's going to pass under that trust agreement. And I think some people think that just because you have the documents in place, it means, I've had people come in and say, oh, I did a will, and I've got a will in place, and it's how everything's going to go. But then you start talking to people, and you find out, well, no, they've got a designated beneficiary here, and they've got their houses joint, and so nothing, that's why you gotta know how things are titled and beneficiary designations, because that's going to trump any documents that you have. The next question is, are there documents in place that some of these assets then will fall within? And it's not uncommon, even with a trust, or even with a trust, that there may be some assets that you still hold jointly. I have a lot of clients who have their bank account, a joint checking account, or maybe they have a car title that's in joint car title. But you still should, on those joint assets, make sure you've got a payable on death or a transfer on death to the trust, because you want to avoid probate generally of those assets. That's a little bit, I think, about wills and trusts, unless there's kind of any other questions about whether you should use a will or a trust as the main document.
One question. So all of your larger assets, but then is it still like an expectation of having a will for smaller, or like personal items like jewelry or
Okay.
collections or something? Like, how would you say that you set it up? I get the fact of like the larger assets, the
Yep.
homes or whatever, but then
So what I would say is this: I would the trust generally, if you do a trust, there's also going to be documents that have an assignment of untitled personal items to your trust. So generally, you will want everything to kind of go through the trust if you've got a trust in place. There are a couple things. Retirement accounts, I'm going to talk a little bit about in just a minute, but there may be some things that pass by beneficiary designation that don't pass directly to the trust. But when you have a trust too, just to be clear, when you have a trust, you also you would have a will, but the will would say everything goes into the trust. It's called a pour over will. And so the only reason in my mind, to have a will, there are a few states that probate's pretty simple, and so maybe having things go under a will, go through probate, would be okay. But most states, you want to avoid probate because it is just a delayed, expensive process. And so most states, like I said, you're not going to want anything to pass under the will if you can avoid it. But sometimes things come up where there are assets that have to be probated after your death that you just can't plan for. Sometimes people would get like a big income tax refund, after their death, or something like that, where it's paid to the individual and it has to go through probate. Or there's some asset that you just forgot about, or maybe they inherited assets that hadn't been transferred to them yet, and the title doesn't get transferred till after death. There could be different scenarios, but having a will in place will make probate less expensive. And so it's always good, even though I said, with using a will or a trust, because then I have people say, well, then I just don't need a will. If I have everything with beneficiary designations, do I need a will? And the answer is, if you can guarantee that there's not going to be anything that comes up after death, then maybe it would be okay. But I think you want a will because it is going to make probate less expensive if something comes up after death. And so with a trust, you still have a will. And if you have minor children, a will is where you name who you want to be your guardians. Because again, the will is the only, the only thing filed with the probate court. A trust is private. A trust is never public record. A trust is only, the only people entitled to the trust would be the beneficiaries of the trust. Now, financial institutions, if you title assets in the name of the trust, many of them ask for copies of the trust. But generally, the only people entitled to the trust are beneficiaries of the trust. The trust, I mean, the will is what's filed with the probate court. It's public document, and it does name guardians if you've got minor children. And that tells the probate judge, who you want to name as guardians for your kids.
So if you have specific items, like she mentioned jewelry, does that all have to go into the trust, or can you just have like a letter saying, I'd like my daughter to get my engagement ring?
Okay.
My favorite painting.
Right. There's generally going to be some document that you sign that just sort of is like a blanket assignment of those untitled personal items to the trust, which is just a kind of a piece of paper that shows it doesn't have to go through probate. But in your estate planning documents, in the trust agreement itself, or if you have a will, you could put it in a will. Most states, if the state allows it, you can dispose of tangible personal property by a separate list. So if your documents allow it or provide for it, you could then, that's a different question than avoiding probate, but you could dispose of specific items of personal property to specific individuals. And if I always put it in my documents, because you don't have to create a list, but if you want to, then it just gives you that option. I have a personal property list. Everything's going to my husband, all my personal property. But I said all of my jewelry, my clothes are going to go to my daughter, because I said I want my husband to remarry, but I just don't want her to have my stuff. But that's an option you can put in the estate planning documents too. Okay, I think I'm trying to see if I've covered everything that I wanted to cover kind of with respect to wills and trusts before we move on. Oh, I know, another important topic I wanted to mention is special needs trusts. Obviously, an important topic for people here. If you have assets that you want to pass to anyone who is on any kind of means-based government program, in particular, most of our kids would be on Medicaid, you really need to make sure that you are not leaving anything to that child directly in the event of your death. Because if they receive assets as an inheritance, then those assets can disqualify them from their government benefits. They would have to spend it down, right? And most of the time, most states, it varies. Medicaid laws vary by state. It's a federal Medicaid, but each state kind of has their own rules. But most states, it's probably like around $2,000 that they can have in assets before it disqualifies them from Medicaid. So one of the things to remember is if you want to leave assets for the benefit of a child who has special needs, or for the event of any person, who is getting any kind of government benefits, disability benefits, that kind of thing, you really need to make sure you put them in a special needs trust for that child. And the states vary slightly, in what the requirements for a special needs trust, but generally it's just going to mean that the trust has to last for the child's lifetime, that the trustee can use the funds in the trustee's discretion, and that the funds can only be used to supplement what they're getting from the government as far as government benefits. But then the trust funds can be used for whatever purpose in supplementing what they're getting from the government. And again, you have to give a lot of thought with special needs trust on who's the trustee of that trust and how that's going to work. For estate planning purposes too, there's kind of there's two different types, what they call special needs trust. For estate planning, where a parent or a grandparent is going to create a special needs trust for their child or grandchild, that's what we call a third-party special needs trust. One of the things you have to be careful is you don't want the child to put any of their own funds into a trust that was created by a parent or a grandparent. Because if a child puts funds into a trust, then there has to be a provision in that trust agreement that says Medicaid gets paid back from those trust funds. So, but most of the time, you know, if we're setting up a special needs trust for a child, it's funds from the parent or the grandparent. And as long as those are the only funds in the trust, then it won't disqualify the child from their benefits, and there doesn't have to be any kind of payback provision to Medicaid in the trust agreement itself. I'm not going to go through that a lot. I think Kate, somebody's talking this afternoon, I think, a little bit more about this. So, yeah. So, I'll kind of leave that up to her. But I think we kind of covered, you know, use of a trust versus a will, and so I won't go through unless you have any more questions. Okay. I'm going to touch base a little bit just on incapacity planning. I think anytime you also do estate planning, hopefully the attorney talks to you about incapacity planning, avoiding what they call lifetime probate. But if you become incapacitated during your lifetime, if you don't have proper documents in place, then your loved ones could have to go to court and be appointed your guardian or conservator, even if you're an adult, but you're incapacitated. And so in order to avoid that, it's really important for people to have in place healthcare directives and durable powers of attorney. A durable power of attorney is for financial matters. It can be very broad. It can be more limited if you want. But you name someone as your agent who can handle pretty much all of your financial matters for you. And you know, by having that in place, then you can hopefully avoid having to have a conservator appointed to handle financial matters if you become incapacitated. One of the things that I will also point out is there's kind of two ways to do durable powers of attorney. One is to make it effective, and I'm talking about financial here, but one is to make it effective immediately, where it just says, you know, I name Barb to be able to write checks on my bank account, to sell my assets, to file for benefits, you know, a whole list of things. Generally, when you do a durable power of attorney, it's going to list very broad powers to handle whatever financial matters might come up. So I could say, okay, Barb immediately can have that, you know, those powers. The other type of power of attorney is called a springing power of attorney, and it says Barb has the power to write checks on my account and all of these powers in the event I become incapacitated, and incapacity is determined by the written statement of a doctor or two doctors or something like that. And I think a lot of people, the immediate reaction is, we want a springing power of attorney because I don't want Barb to just be able to take this and write checks on my bank account. But the reality is springing powers of attorney are just not as well accepted. And what ends up happening a lot of times is, I've had multiple times where a client will take it to UBS or their parent's broker because their parent is incapacitated and they've been named as the agent and they got their doctor's letter, and UBS looks at it and says, I don't know you, I don't know this doctor, I'm not going to let you write checks on their brokerage account. And so I think most attorneys now draft them where they're effective immediately. And I think that is important. That's the way I do mine. And I just tell people, you know, don't give them to your agent. You know, a financial power of attorney, rarely is there an emergency where they have to immediately have access to the finances. Usually it can last a few days. And so just tell them where it is. You know, if you're not comfortable giving it out, and honestly, because you might change your mind on who you want to name down the road, you know, sometimes it's just better, I think, on financial powers of attorney, just to kind of hold them a little bit close and not really give them to the agent. That's just my own personal thought. Sure.
When you say to the agent, could that be like your child?
Yeah, it could be. So typically, when I say called your agent or your attorney, in fact, and that's just the person that you're naming to handle the financial matters. So it can be typically, if you're married, it'd be your spouse first, and then it could be a child as a backup. It could be anyone really. I mean, whoever you would want to pay your bills, file your tax returns, all of those kinds of things. If you're incapacitated, that's who you should name. Oh, I absolutely would tell them. I would tell them that you've done it. And spouse, I mean, obviously, generally, most of the time, your spouse can access whatever you've got. I'm just saying, if you've named a backup agent, you don't necessarily have to give it to them. But I would let them know that you've got a durable power of attorney in place, and that, yeah, I'm saying they know where to find it, so that if you would become incapacitated, they have access to it and can get to it. But it's just not something that's easily available. And that's just my own 2 cents worth. I mean, I think you can obviously give them copies if you want to give them copies. And while I do think people worry about misuse of durable powers of attorney, I will say my own personal experience, and I've been practicing for almost 40 years now, is I've only had one time where someone has misused a power of attorney, and at the time they signed it, I said, please don't sign this power of attorney. And they did anyway. And fortunately, because of the sort of sick feeling that I had, and luckily they also had a trust in place, and they had a financial institution that I talked to, and I said, if there's anything weird that goes on, this person was going into kind of an assisted living. And I said, if there's anything weird going on, maybe keep an eye on it. And like the next day, like $40,000 was taken out of the account. And so we caught it, pretty quickly. But I do think, I think it's your own comfort level. And I don't, again, that's just my 2 cents worth. On the other thing, in addition, oh, sure. Right. And just to be clear too, because I think people get really confused on this, and it can cause a lot of frustration. They'll go down. A durable power of attorney allows you to handle assets that are in the individual's name. Okay. So, it would be a bank account titled Kim Zellmer. If it's titled in the Kim Zellmer Trust, the durable power of attorney doesn't have any authority over that. It would be the successor trustee named in the trust agreement who would have authority to make decisions on the trust account. So I think I have a lot of times where clients will try to take a durable power of attorney, and they'll say, they won't let me do anything on this trust account at my bank. And I'll say, well, the other thing is, a durable power of attorney is only effective during your lifetime, or during the lifetime of the person who created the principal. So immediately at death, that power, the authority under that power of attorney goes away.
So is it a best practice to make that trustee, the successor trustee, and the durable power attorney the same person if possible?
Yeah.
Or is there reason to do it separately, maybe as a check and balance?
I think generally, people name the same ones. I kind of feel like, I think that works better, because then they can have access to all of the assets to pay the bills and file the tax returns and all of that, rather than, unless you just want two people involved. But generally, I think you'd want to name the same on both. It makes it a little bit simpler, I think. So in addition to durable power of attorney for financial matters, having a health care directive, and it can be called a lot of different things in different states: an advance directive, a health care directive. There's living, and those kind of, generally when you say an advance directive or a health care directive, they encompass several things, but sometimes people divide these up in different documents too. And one is kind of a living will provisions, which just say if you have a terminal illness or an irreversible condition where you can't make medical decisions on your own. I'm sorry, living will. I got sidetracked. My brain went a different direction. A living will part, which just says if you have a terminal condition or if you have an irreversible condition and you have no meaningful quality of life, that you don't want extraordinary measures. That's the living will part. Healthcare power of attorney, which is where I was going with the other, is naming someone to make medical decisions for you if you can't make those decisions on your own. And a HIPAA waiver. And so typically, you know, an advanced directive, healthcare directives, those kind of combine all those a lot of times. Sometimes they're all in separate documents. But all of those things are important to have in place. The other thing I was going to mention is that once your child turns age 18, that you no longer have legal authority to handle decisions on their behalf, even if your child's incapacitated. And so this kind of works, a couple of points on this. If you've got a child with Batten disease or, you know, with any other kind of, you know, incapacity when they're at the time they turn 18, you may have to look into getting a guardianship for the child in order to be able to make you know, financial medical decisions for that child. Just to be aware of that you won't automatically have legal authority after they reach age 18. The other thing I would point out is if you've got children who are getting ready to go away to college, you might want to have them sign a durable power of attorney and a healthcare directive that gives you the authority to have access to their financial accounts or also to be able to make medical decisions if they would have a medical emergency, because again, you lose that once the child turns 18. And so I always kind of try to remind people that they might want to think about something if their child is, you know, if you want to talk to your child about that. I think that's kind of incapacity planning. I'm going to touch base on taxes, everybody's favorite topic, but sort of the good news is most people don't really have to worry about taxes. There's several different taxes, and you kind of have to keep clear what we're talking about. But I think I'm trying to look. Estate taxes, it used to be when I started, and for most of the time I've been practicing, estate taxes kind of drove all estate planning because the estate tax exemption amount was fairly low, and so everybody had to worry about estate taxes. If your estate is under the exemption amount, then you don't have to worry about estate taxes. And the exemption this year is $13.99 million. And as part of the big, beautiful bill, next year it's going to be $15 million. And it's indexed each year for inflation. And that's per person. So married couples can pass $30 million. Less than 1% of the population. I think it's even I saw 0.14%, I think, of the population has to worry about estate taxes now. So I'm not going to really focus that much time on estate taxes because if you need help, I can help you, but we can talk later. Most people aren't going to have to worry about it. That's the key to remember. I guess one thing that I would say, though, there are still some states that have state, estate, or inheritance taxes. I've got some handouts here I can give you. I did a quick chat GPT, and I put the states in here. I did not verify them, and I put a little footnote to show that. But if you're in a state that has state, estate, or inheritance taxes, you might check on that because that might apply to you. But federal estate taxes, most people aren't going to have to worry about. And most states don't have estate or inheritance taxes any longer. There are still some, though, that do. I wanted to also just touch base briefly on gift taxes. I'm going to spend a minute on that because I think people should know kind of how gift taxes work. Gift taxes are coordinated with estate taxes. So when I say, I'm just going to say we have a $15 million exemption, which is what the exemption is going to be next year. So the gift tax exemption is in the estate tax exemption. It's really a transfer tax exemption. And with gift taxes, you also have what's called an annual gift tax exclusion. And that is indexed for inflation as well, but it's $19,000. So you can give $19,000 to any person each year without any tax consequences, without filing a gift tax return. If your spouse agrees to join in on the gift, it can be $38,000 per year. So if you're gifting to your child, paying for things, right, you don't have to file a gift tax return. You don't have to do anything. Once you go over that amount, over the annual exclusion amount, then you're required to file a gift tax return and report that gift. And the amount that's in excess of your gift tax exclusion will just use up part of your transfer tax exclusion. So you'll have a little bit less available at your death. Because the exemption is so high, it really is kind of, it just means that if you gift more than the $19,000 per beneficiary per year, you're required to file a gift tax return. You won't have to pay any taxes unless you are very generous and gave more than $15 million. But so most of the time it just means filing a gift tax return. I guess I'll also point out that the estate tax exemption is at historic highs. And so there's no guarantee it will always be this high. It hasn't gone down, it has just gone up. So, but I won't guarantee. I think it's something that to keep in mind if we get a change in political parties in charge and all of that. There's always a possibility that some new tax bill could lower the estate tax exemption. So I will only point that out just to keep that in mind. But right now we have $15 million. There are no sunset provisions, so it's a permanent exemption, and it should go up a little bit each year because of the index for inflation. So estate taxes, gift taxes, not big taxes people have to worry about. Income taxes, I get another question, well, are they going to have to pay income taxes on what they inherit? And the general answer is no, they don't pay income taxes on what they inherit. If they get life insurance proceeds, if they get, if they inherit bank accounts, things like that, they're not going to pay income taxes on that. The one primary exception is retirement accounts, IRA accounts. So tax-deferred retirement accounts, your beneficiaries are going to have to pay income taxes when they draw the funds out of the account. And so that's something that sometimes takes a little bit of planning just to for that purpose. And it's obviously just tax deferred, so like not Roths. Obviously, they don't have to pay income tax on Roths, just IRAs, 401ks, that kind of stuff. With retirement accounts, IRAs, those kind of things, if you're married, the most tax efficient is going to be to name your spouse as the primary beneficiary. So even if you have a trust, you'd want to name your spouse directly as the primary beneficiary, because your spouse has options to roll over that into their own IRA account and are generally going to be able to defer the income taxes longer than any other beneficiary. Most other beneficiaries are going to have they're going to have 10 years to take the funds out of the account. So they're going to have to pay the income taxes as they take it out. And depending on whether the person dies before their required beginning date or after, they may have to take a little bit out every year, or they may opt to take it all out in year 10. But they're going to have to pay the income taxes when the funds are taken out of the account. So that's something to keep it. Yeah. They can't. They cannot. Yeah, they take it as an inherited IRA, and they'll have to take it out over the 10-year period. And I mean, there's some exceptions. One being if you've got incapacitated or beneficiaries, they're given a longer time to take it out. They can take it out over their life expectancy. If you've got minor children, the 10 years doesn't start until they're, I can't remember if it's 21 or 25. Do you know? Anyway, they have until they're, it's either 21 or 25, and I don't know why I'm kind of blanking on which one, but they're 10-year. I kind of think it is too. At first I thought it was 21, but I think they give them till 25, and then they have 10 years to take it out, and that only applies to children. It doesn't apply to other minor beneficiaries. but most non-spouse beneficiaries, the maximum amount of time they're going to have is 10 years. And also, the thing to keep in mind is the 10 years is something they have to elect, because sometimes beneficiaries aren't as smart, and they may just take it all out in one year. They could take the whole thing in year one and have to pay all the income taxes. And a lot of people, their retirement accounts are kind of their primary asset. And so if you think about having to take all of that income in 1 year, it can be a pretty significant income tax burden. So you might want to have that conversation with your kids if you're leaving it, naming them as beneficiary, that they kind of understand that it's not very smart generally to take it all out in one lump sum, because you're going to have a pretty hefty tax. The other thing I was going to point out, just with respect to taxes, is assets that your beneficiaries receive at your death. If those assets are included in your estate at your death, then your beneficiaries will get a step up in basis for those assets. And what that means is assets that appreciate in value, so I'm talking like stocks, your home, real estate, things that have appreciated. If you bought a stock for $100 and it was worth $300 right before you died, if you sold it right before you died, you'd have a $200 capital gain tax that you'd have to pay tax on. If you bought it for $100, at your date of death, it's worth $300, and your beneficiaries sell it right after your death, their basis isn't the $100. They get a step up in basis. It's the $300. It's the date of death value of that asset. So most of the assets, if they appreciate in value and they sell them fairly quickly after, they're not going to have to, they're not going to have any income or a large capital gains tax that they have to pay, because it's only any increase from date of death. And also, I kind of try to remind people, sometimes I get clients who come in and they're old. They may be in their 90s, and they'll say, I've decided I'm going to gift this farm to my grandkids because, I can't farm it anymore, and they're doing all the work. And I try to tell them that that's really not a great plan, because if they would hold it until, especially a farm that they bought back for nothing, and now the farm's worth a lot of money, if they wait until after their death, then their grandkids are going to get a step up in basis. And so eventually, if they decide to sell the farm, they'll have much less income tax that they'll have to pay. So that's, I think, plenty on taxes. I think we're almost out of time. So I do want to touch base just on charitable planning, because I do think that's also something that people should think about, is whether to include charities in your estate plan. And I think I try to encourage clients to at least think whether there's any role that charities have to play. And certainly when you've got a spouse and young kids, the answer may be no, not at this time. But also charities might be a contingent beneficiary. If something happens to your spouse and kids, maybe charities can fit in the estate plan at that point in time. I just encourage you to think about it. And if you want to make charitable gifts, retirement accounts are great ways to make those charitable gifts, because, as we just talked about, if you give it to your kids are going to pay income tax when they take the funds out of the account. If you give it to a charity, they're going to get the full amount. There's not going to be income tax. So if you want to leave something to charity, naming a charity as a beneficiary on your retirement account. You don't have to give them all. You could give them part of it. I think that's a great way to fulfill charitable wishes if that's what you want to do.
Sorry to interrupt. You can select a percentage of your IRA.
Yeah.
You can select a certain dollar amount
Right.
for each beneficiary.
That's correct.
So
Yeah.
It gives you a lot of options.
Right.
See, I didn't know I needed to do that, because like when we wrote our will, we just said a percentage of the total assets
Right.
went towards BDSRA. But we need to say, because Randy's, our
Right.
biggest asset is his retirement.
Right.
So we should mark it on his retirement fund?
You can do that.
specifically?
You can do that. You can do that. You can do it. You can do it that way. If you have a trust, you can also, in your trust agreement, it just needs to make sure that it says that the charitable gift will be satisfied with retirement accounts, and hopefully your attorney would do that. But that's also another option. So you could either name it directly on the beneficiary form, or in the document itself, it can be specified that charitable bequest will be satisfied to the extent possible with retirement benefits.
Darlene, it also depends on if you have other, like Kim said, other people involved. Your last resort can be the charity. So in my case, if my brother survives me,
Yeah.
my brother is the trustee of my trust.
Right.
So he makes the decisions about it. And in the trust document, I specified X amount of dollars to BDSRA.
Okay.
And then he can do whatever he wants with the rest of it. I don't care about it.
Oh, okay, so,
Okay.
but you put all yours into a trust.
Right. If he
Okay.
dies first, then I need to get you documents for my trust. Because I've got everything going to the charity.
Okay, because see, my niece is in charge of is our executor, but like I said, we just put a percentage of whatever is left. 'Cause we
Right.
don't want to use it.
Yeah.
You know,
Yeah.
but,
Yeah, that works.
It's just a percentage, but it doesn't state retirement fund. So, is that something that we should?
Well,
ask
you could
about?
do it one of two ways. I think you could either do it through your retirement account and then just take it out of your estate planning documents. So it's going to pass through the retirement account, beneficiary designation on the retirement account, or you can, in your document itself, you can say it's going to be paid through through retirement accounts.
Okay. Well, it doesn't specifically say retirement, it just says after our
Yeah.
debt has been paid,
Right,
the balance of the assets.
right.
So I didn't know if that
That
meant.
should cover it, right? Because that retirement account will become the assets left. If it's charitable, you
Yeah.
don't have to worry about the tax ramifications.
Okay, well, that's what I was trying to figure out.
There are ways to plan around it after death too. That that if you can pay off the other beneficiaries, retirement account rules. I've decided whoever in the government is in charge of writing those rules. I mean, it is. It's just ridiculous when you
After
think.
a few beers, they sit down, say, let's try this.
Well, I mean, I think. I think who would make an age, when it used to be age 70 and a half, you just feel like that's two people arguing and they finally just said, oh, we're going to make it 70 and a half. And one of the other rules, it's when they look at, who's the beneficiary on the retirement account, it's not, who's the when they're trying to decide, especially if it's paid to a trust, they look at who is left on September 30th of the year following the year of death. I don't know how they come up with that. So if you can pay out all the beneficiaries before that time and the only beneficiary that's left is charity, then it works too. But you have to kind of do some finagling a little bit and try to make sure you fall within that. But
Even if you're, one other question, or just a clarification, if your largest asset base is the retirement accounts, and you put the beneficiary as your last will and testament, and it's spelled out in your will, that's fine too, right?
you can do that. You probably don't want to name your estate or your will as a beneficiary on a retirement account. Because that will mean it is going to be probated. It'll have to go through probate.
I took a lot of notes, 'cause that's
Okay.
how we are set up, and I think we have to change it. We're at the point where we have to change anyway. There's so many things that have changed in 20 years, so, yeah, that was one thing that I took from this, is about avoiding the probate by
Right.
moving things out of the will.
Right. A will only governs assets that go through probate. So you have to, unless your estate is one of the ones that has a very simple probate, I would try to avoid probate. And so you don't want anything paid to your estate, and especially retirement accounts, because if your retirement account is actually paid to your estate, then you don't even get the 10-year payout. You have to get it paid out within 5 years. So you don't want that, I will say.
Yeah, I'm trying to think, why would you even do that?
Yeah. Well, I don't know. I'm not going to try to second guess. I would say my other last final piece of advice is when you go to get your estate planning done, try to find an attorney that's all they do is estate planning, because it is an area where I think, unfortunately, you get a lot of attorneys who kind of feel like I can go get that will or that trust form, and you know, and they don't understand necessarily all of the reasoning behind what they're doing, and and so there's a lot of great estate planning attorneys, and that's all they do, and maybe if they did a little bit real estate or something on the side, that's fine. But if you get somebody who does estate planning and litigation in particular, or unless it's probate litigation, specifically, but if you get someone who does a lot of different things, I would try to avoid that, because I think you'll get better served by someone who just focuses in on estate planning. And I think most places they have, groups that are just estate planning attorneys.
Our lawyer had a special needs child.
Yeah.
So when we went to him before the girls passed away, he helped us set ours up.
Right.
That because he knew all about it.
Right.
And so it was very helpful going to him.
Yeah. Yeah. I think that is. I think, and I think in particular, obviously with special needs trusts, that is even more complex. And certainly I think somebody who's just more of a general practitioner, you don't want somebody involved in that, because the Medicaid rules are pretty strict on, what would qualify as a resource. And even if you have it in a trust, unless it's, a trust that has specific, provisions in it, it can disqualify you even if you're having it held in trust for a child with special needs. So you have to be really careful about all that. No, that's fine. Right.
I'm smiling because that explains a lot of some of the decisions in the carrier side of my dad's family. But some of his siblings were, could have been affected because they were.
Yeah. Well, I agree. I mean, I think for anyone, I think having that in place, and it's just important because nobody knows what's going to happen and to any of us, and so it's not the most fun thing to think about, but it is important to get in place, and then
The earlier you can get people thinking about it, though, the better it is.
right. Right.
And to make sure that your will, that your need, your wants are answered. Because otherwise you're leaving it up to whoever's doing it.
And there's nothing more uncomfortable than having someone who comes in with no plan, and they're have gotten a bad diagnosis, or something like that, or clearly it's a parent who is you're not quite sure they really understand what's going on, and you're trying to decide whether or not they can, they should be doing this, and you just don't want to be in that situation. It's not fun to think about estate planning, but people who are thinking about it with a more immediate sense, it's just not very pleasant. I don't think you make as good a decisions, and so.
One more comment too,
Huh?
something that I did a long time ago that I think is so interesting, and whenever I'm in this type of setting, I always bring it up, is that I created like a book of life, and in that binder, like with sleeves, I have titles of our vehicles. So
Yes.
people, if we have a loan on something, if they're, life insurance, if it's through a separate, contact, we have like an online banking, where that is, who to contact, because we have storage for a camper, we have storage for a boat. So it's kind of like just letting people know if something happens to both of us.
Oh, I
here's
agree
where stuff is.
100%. And it is something that I tell my clients as part of the planning. I say, we'll handle the legal stuff, but, nowadays too, just finding out what the assets are can be so challenging. And, it used to be back in the golden days when I was, started practicing, I'd just say, well, monitor the mail and they'll get their monthly statements. And, and now, I just had a family member, my brother-in-law passed away, and I mean, we're going through stuff, trying to figure out where things are, and it is really challenging. And I don't even know if we found everything, which is kind of the scary part. And so I do think that there's always the practical side of planning as well. And I tell people, do what you did. Put together a good list of your assets and include, if there are contact people. The dollar amounts don't matter, but put down the accounts, put down how they're titled, if there are beneficiary designations, and put all in passwords. Put together all of your important documents in one place, and get rid of those old electric bills from 10 years ago that you've got in a folder somewhere. Because I think there's a lot of people who've, and I'm guilty of some of it too, but I have been trying to go through and get rid of a lot of stuff, because somebody's going to have to go through that. If you leave it, I mean, I'm going through this with my brother-in-law now. I'm going through stuff, and I'm just like, why did he keep this, but I'm still going through it because I don't want to throw something away that turns out to be important. So,
And you're an attorney with a higher skill set. You figure if somebody else is coming in and they may not have that skill set of knowing what's important, what's not important, there could be, you could miss out on $100,000.
I think I'm all in favor of trying to simplify and get rid of stuff.
Book of life.
Yeah.
I went to a seminar at the health system that I used to work with, and she was a social worker by trade, but she talked about that. I forget what she called it, but it was in the top of the closet in the guest bedroom,
Mhm.
and nobody had to look at it, but everybody had to know where it was.
Right. Right.
She made jokes about it, I think she called it the death book or something
I
like
originally did, and everybody thought that was too morbid, so
But
I changed it.
I think she talked about her daughters, and to them it was kind of comical, comic relief.
Well, please don't do what my mother did. She had her safety deposit book, and she said, now girls, here's the key. When it gets to the point where you need to go and get it, everything's in there. Well, we put her in the nursing home, and when we went to there to get it, everything was outdated.
Yeah.
Nothing in there was anything that we needed.
Yeah.
I mean, she totally didn't realize it was all like
Yeah.
10 or 20 years old, and nothing was up to date. It was like, Mom, what are you doing here?
I'm more worried. My mom is a pack rat, and I've told her that at her death, if she does not do some cleaning out before that, we are just burning down her house,
There you go.
because I am not going through it all.
I hear up and down. Tax records are like at 5, 7, 10.
7 was. Is it?
Well, I think that's a good amount. I think as long as there's,
5, 7, or 10.
I would probably say 7. I mean, I think that's good. I hear different things too as well.
Well,
but-
businesses always use, at least
Yeah.
most businesses use 7.
Yeah, I think that's a good number. I have heard different things as well. I don't know that there is a uniform recommendation, but
I think after 7 years, if they haven't come after it,
3 years is unless there's fraud. 3 years is the maximum they'll go back.
Most banking institutions, or at least in my experience, you can get back like 2 or 3 years at least online.
Yeah.
Well,
And then
online, yeah, now you
and
can.
then, but then,
but-
yeah, but back then you could. Now,
But-
but now, there's no reason to keep that stuff, because even if you have to call the bank and say, hey, can you send me a copy of 2 years ago March? Yeah, that's gonna be $10. Okay,
Yeah.
it's worth it not to have that, all that
Right.
piled
But
in the
5
corner.
years ago.
I
you
also-
couldn't have done that.
I guess I'm also a fan of if your computer savvy is a scanner and not having a lot of paper records. It's just
cloud
scanning
account.
things and keeping them on your computer. But then you have to make sure somebody knows how to get into the computer and
High-level security.
right. So, okay.
Thank you very much.
Okay, sure.
Great.